public space, but it's also where a lot of people live. So you can't ask someone to not walk by Library Walk just because they don't want to see what's there, because this is also where they live. You can't ask African American students or students that are going to be offended by what's in the Koala to stay at home, because this is also where they live. This is a communal space, and then we have to respect that. We cannot allow fighting words that they really do cause immediate breach of peace, and we can't allow that. We can't fund that. And mass censorship is not the answer, but we need to defund the Koala now, because it's not.
I was going to wait, but it seems like this fighting words doctrine seems to be brought up a lot. And I just want to clarify, the specific language that the Supreme Court uses is by mere utterance alone causes imminent unlawful action. So we can break that into two parts. First part is by mere utterance. Supreme Court has never, no court actually, has ever upheld that words that are written can be considered fighting words. Why? Because you have the opportunity to not read them. As soon as you make the choice to read those words, it is no longer mere utterance. Now, if the Koala was out there, demonstrating, yelling things, and those things can very easily be construed as fighting words. Of course, that's something that the Koala staff often has to take into consideration. But there is no single piece of jurisprudence that's ever been prosecuted. In fact, there's a professor here at UCSD, I forget his first name, Iron. He argues that it's impossible even for fighting words to be applied to any written speech, because the simple act of choosing to read it and interpret it means that it's not an immediate unlawful action. It's just an unlawful action, and that individual has made that choice. Secondly, the second part is imminent unlawful action. Someone has to do something illegal for it to be fighting words. If you're going to use fighting words as a defense, typically the way it happens is someone says something to someone, and that other person punches the person in the face. Now, obviously I'm not advocating violence, but I'm saying that the application of that particular ruling is being completely blown out of proportion. It's not fighting words because it's not mere utterance. If people are choosing to read it and then they're deciding to get upset. I mean, these are decisions that are being made. How much they believe their involvement in that decision in the cognitive process is something that might be brought up for debate. But again, all this quote mining, where they talk about, by mere utterance alone. Yes, by mere utterance. It has to come out of my mouth. I have to utter it. Writing is not utterance. And secondly, no unlawful action has been taken, unless you want to try and say that, violating the ban on affirmative action is because of the quality. Great, that sounds like an awesome defense. I would love to see that argued in court, and if it worked, I would love to say that the fighting words that I use cause affirmative action to go through because it caused immediate unlawful, action by the university. But it's impossible. It's just, everyone's using that term fighting words because it sounds like, oh, it's close, it makes me want to fight, and they're words. No. It has to be my mere utterance alone. So I think we should completely reject that. The other one that's probably going to be brought up is equal protection under the law, the 14th Amendment. Firstly, the First Amendment is included in the 14th Amendment. You can't violate the First Amendment to uphold the 14th. Just the same as you can't violate the Second Amendment to uphold the 14th. You can't violate any of the Constitution, any of the ones that came before it. But more importantly, in a specific court case, Rosenberger v. University of Virginia, the Supreme Court upheld that speech made by students is private speech. It's not public speech. It doesn't belong to the university. Even though might be funded by the university, it's still considered the private speech of those individuals. And the Equal Protection Clause is inapplicable to private speech. It's only applicable to government speech. It says that the government has to apply all protections equal to all students. For example, when AS passes a rule that says we're only going to defund the Koala, that technically is also a violation of the 14th Amendment because it doesn't provide the same protections to one group as it does to others. And also people have talked about the O'Brien case. I've seen that one come up a lot. That's an interesting one because they're trying to say that, because the Koala might theoretically be able to fund itself, therefore it's not an actual violation of their First Amendment rights. Also false. If you've ever read the O'Brien case, it specifically states that the burning of a draft card was not considered a violation of that person's First Amendment rights because the draft card served some other purpose. It wasn't simply an expressive piece of speech. And it was actually Harlan, who some of you might live in. Harlan Hall, he's a Supreme Court justice. Harlan said that the crux of this case is that it wasn't expressive freedoms that were being violated. It wasn't this person saying something or thinking something. It was simply this person using this draft card, which had a very important purpose. to express themselves, and they could have expressed themselves in other completely legal and protected ways. So I think that all of these, sort of these legal arguments, you know, it's an example of how just a little bit of knowledge can be a very dangerous thing. And it just harkens back to the idea that, you know, if we had an open debate, if you guys hadn't frozen the funds, if the BSU had the opportunity to release a newsletter or talk about these things or have a real open public debate, I don't think this would be the first time we'd be talking about these things. But the fact that this is the first time says something very scary about the state of speech at UCSD.
30 seconds.
And that's about it. Thanks.
Hi, my name is Caroline, and I'm from BAN, the Coalition to Defend Affirmative Action, Integration, Immigrant Rights, and Fight for Equality by Any Means Necessary. I wanted to read something that we brought to the campus today. It's an open letter to the UC San Diego Black Student Union and to all students fighting racist attacks and racist exclusion in UC and standing in defense of public education. BAM congratulates the BSU and all of the Black, Latino, and Latina, Native American, and other students who have waged the brave and inspiring struggle against the overt racism and hostility at UC San Diego. We know from our own experience that each student had to reach deep inside to overcome their fears and threats and to summon the courage needed to stand up for minority students' rights. We know as well how proud you are at having fought and won. Your fight has inspired students at other campuses of the UC and at campuses across the nation. Students in South Africa, Mexico, and in other countries demonstrated on March 4th in solidarity with our efforts here to save public education and to oppose the increased disparities in opportunity and access based on institutional racism. Because you fought, Ward Connolly has now declared that he will be, quote, reviewing the settlement that you reached with the administration. As always, Connolly says nothing about the nooses, the hoods, or the climate of racism. His only concern is to end the slightest steps towards restoring fairness, equality, and affirmative action. Connolly is a racist bully, but like all bullies, he can be defeated. BAM beat him in 2001 when we built student demonstrations so powerful throughout the UC system that he was forced as a UC regent to vote against the ban on affirmative action in the UC system that he had campaigned relentlessly to win. We beat him in 2003 when we organized over 50,000 young people from all across the nation to march on Washington, D.C. when the U.S. Supreme Court heard the landmark University of Michigan Grutter v. Bollinger case. We represented the student defendants in that case who stood side by side with the University of Michigan defending affirmative action, and together we won. In 2008, when Ward Connolly announced he intended to make the November election day his Super Tuesday by getting anti-affirmative action referendums passed in 5 states, we mobilized like crazy. Using BAM's tactics of direct action and policy of exposing Connolly's tactics of using racially targeted voter fraud to get his ballot referendums placed before the electorate, the new civil rights defeated him in Oklahoma, Missouri, Arizona, and Colorado, turning his Super Tuesday into his Super Lose Day. In California, over the past 5 years, we defeated Connolly's attempt to use Prop 209 to end the Los Angeles and Berkeley school district's highly successful K-12 desegregation programs. Last month, we filed suit in California to strike down Prop 209 in the federal courts. If Ward Connolly threatens one syllable of the agreement that you reached with UC San Diego, we would be proud to provide whatever legal and political support you need to defeat him. Connolly's Proposition 209 remains as the crucial obstacle to our shared fight to stop the resegregation of the UC system, to increase underrepresented minority student enrollment, and to restore UC's historical commitment to educate the next generation of leaders for California and the nation. In a state that is now majority minority, it is simply unacceptable to have only a tiny number of Black, Latino, Native American students attending the UCs. Every successful measure we win to increase Black, Latino, and Native American enrollment, Ward Connolly denounces and threatens to file suit against. Ending this relentless attack against equality and the democratic principles of public education requires decisively defeating Ward Connolly. Towards this end, we invite the BSU and every other progressive UC organization, including the student government, to join with us as plaintiffs in the lawsuit we just filed. Can I ask for extra time?